Counsel, you have spent quite a bit of your brief talking about the tradition of public accommodations laws. Would you just spend a few minutes or whatever amount of time you can explaining whether there is a similarly long tradition of public accommodations laws applying to speech or expressive conduct?
Well, certainly, Justice Thomas, the history of public accommodation laws shows that when those held themselves open to the public, they were required to serve everything.
I understand. The complicating factor here, is this is not a hotel, this is not a restaurant, this is not a riverboat or a train. I'm interested in the intersection of public accommodations law and speech.
I think we see some public accommodation law being applied to examples that are speech today, tailors, barbers, et cetera. But what we don't see over the long history of public accommodation laws in this country is people raising First Amendment speech objections to those laws applying to it.
Well, I think that in part depends upon whether or not you're engaging in speech. If you're running a train business or a riverboat business, that's not exactly, doesn't implicate speech. So those are straightforward. I understand that. What I'm interested in is when you are talking about public accommodations laws directly or indirectly regulating speech, is there a tradition of that? Can you point to cases? Can you point to common law treatises, et cetera?
So I think that the historical record is sparse on both sides, but the two things I would say, Justice Thomas, is what we don't see is a history of public accommodation laws carving out speech. They all are laws of general applicability that apply to all those operating a trade to the public. They don't say except those engaged in expressive conduct. And with that framework, we do not see a history of cases where people raised their hand and said it shouldn't apply to me because I'm speaking. And so I think the public accommodations brief on our side in this case sets that out quite nicely, but there is no case from 150 years ago that comes out either way with this exact issue.
Mr. Olson.
Counsel, would you spend just a few minutes on whether or not this your case is ripe?
Sure. This court has considered pre-enforcement challenges before, and in those contexts, it has looked at the facts. This is one of the strongest pre-enforcement cases I think that this court has considered, in that the parties have stipulated every message that Ms. Smith would create has a unique, customized message, then that it celebrates a wedding and celebrates a marriage. It's also difficult to imagine a scenario where there is a more aggressive enforcement history by Colorado. Ms. Smith's speech has been chilled for 6 years. She has been unable to speak in the marketplace. She's ready to do so today, and she's ready to post her website statement today, which makes this case ripe.